Thanks for joining Thompson Hine's weekly coffee chat series. I'm Mike Wible, a partner in Thompson Hine's investment management practice group. This is our 38th webinar in our weekly coffee chat series. These short and practical discussions focus on a variety of developments that impact the financial services industry. Joining me today is Steve Stransky. Steve is a partner in our Cleveland office and co-chair of Thompson Hine's Privacy and Cybersecurity practice. Steve helps clients assess and mitigate cybersecurity and privacy risks. He helps them respond to cyber attacks and data breaches and maintain compliance with federal, state, and foreign laws and regulations governing data protection. Before joining Thompson Hine, Steve was a senior counsel in the Department of Homeland Security, where he oversaw the department's foreign intelligence, counterintelligence, and security intelligence activities. This included producing cybersecurity threat assessments and data breach responses for the private sector. Steve also served as a deputy legal advisor to the President's National Security Council, an increase in the number of cyber attacks against SEC-registered investment advisors and broker-dealers. The office has issued a number of risk alerts on ransomware attacks, credential stuffing, which is an attempt to compromise login credentials, and security risks associated with the storage of electronic customer records and information in various network storage solutions like cloud-based storage. Today, Steve and I will talk about responding to cybersecurity incidents, including the development of a cyber incident response plan and any state and federal reporting and customer identification obligations. We'll also talk about the SEC's recently proposed cybersecurity risk management rules for registered investment advisors and funds. If you have any questions or comments during today's program, we encourage you to join the discussion by using the Q&A box at the top of your control panel. We'll address your comments as we move through the discussion, and we'll try to leave some time at the end of the session for your questions. If we don't get to your questions, don't worry. We'll follow up after the program. Before we start, it's always useful to cover a few key concepts and terms. We often hear the term cyber incident. In fact, in the SEC's proposed new rules, they also use the term cyber incident. Steve, can you define for us or tell us how you define the term cyber incident?
Sure, and that's a key part of the proposed rule by the SEC is to require covered investors and funds to report cyber incidents within 48 hours to the Commission. And how the term cyber incident or data breach or security event is going to be defined is going to vary across the different legal landscapes in which it's actually applied. So for example, in the consumer data protection world, the definition of a data breach is essentially the compromise of personal information of an individual. That means the unauthorized access, use, or acquisition of personal information. And so this definition is very, very narrow because the purpose of a consumer data protection law is to require organizations to notify individuals who have been affected by a breach or security incidents, so they in turn can then undertake measures to better protect themselves, right? Identity theft protection monitoring, changing usernames and passwords. So that's why we have a definition of a security breach that's geared towards the compromise of information. On the other hand, we have federal laws that encourage critical infrastructure organizations to report cyber incidents to the federal government, but these laws are more geared or identify a cyber incident in a type of attack, whether it's a ransomware attack or some type of cybersecurity event that compromises an IT environment. And the government requests access to this information, not necessarily to protect individuals, right, in the consumer context. It's so they could better understand the cyber landscape. They could better understand the tactics, the techniques, and the procedures that are used by foreign adversaries or malicious actors, so they can try to attribute those type of activities to an organization for intelligence, sanction purposes, things like that. Also, so they could share the information with other entities within that same critical infrastructure space, so they can better protect themselves. And so what we see from the SEC's definition of essentially a reportable cybersecurity incident is it really covers both of these areas. It defines a cybersecurity incident on one hand as an event that significantly disrupts or degrades an organization's ability to maintain critical operations, or some type of incident that could lead to unauthorized access to advisor information that could lead to substantial harm. So you have two different prongs there. And within the proposed rule itself, the SEC tries to provide examples of what this rule actually means, or what the definition means. And so here they define or provide an idea of what a critical operation is for an investor or fund as essentially anything related to investing, trading, reporting, risk management. And they really focus in on ransomware attacks and malware attacks and something called a DDoS attack, a distributed denial of service attack. And what the SEC essentially says in their rule is that when you're subject to ransomware, when you're subject to widespread malware that compromises your ability to actually engage in trading, in strategic investing, advising, preventing your clients from being able to access their own accounts, this could impact the market, right? This could impact individuals' abilities to engage in financial transactions, but it could also impact the market at a larger scale because this type of ransomware attack or malware attack could spread to other organizations. That's why it's considered a cybersecurity event that impacts critical operations that must be reported to the SEC within that 48-hour window. And then the second phase of this is, again, the SEC focuses in on really the unauthorized access to advisor information. Again, when this occurs, it must be reported to the SEC within that 48-hour window. And the examples the SEC gives here, very similar to the consumer context. It essentially says that when personal information, when intellectual property, when trade secrets, when portfolio information, when that type of data is compromised, it could lead to harm to an individual, whether it's reputational damage, their information, personal information could be sold on the dark net, used for identity theft purposes. Again, these are the type of issues that could lead to substantial harm, and therefore it has to be reported to the SEC. So again, in the SEC's definition of what would be considered a covered cybersecurity incident, focuses on two prongs. The first on whether or not an incident impacts critical operations, and the second prong is whether or not it compromises certain types of data sets.
Yeah, and I think that that's shown also in as they use throughout the proposed rule, they use the terminology information systems and information saved or stored on those information systems. So they're getting to those two prongs, the systems themselves as well as the personal data that's saved. So the other term we'll talk about is incident response plan. Steve, can you talk about various elements of an incident response plan and why it's necessary to have one?
Sure, absolutely. So first, it could be necessary because it's required by law to have an incident response plan, but if it's not required by law, it's still certainly a best practice. And this is an area that we assist a lot of our clients. And so Thompson Hine, we actually drafted an incident response plan checklist, and it's posted on our website for anybody to use at thompsonhine.com on our Privacy and Cybersecurity Practice Group website. You can see a checklist of the issues that we think are critical to be included in an incident response plan, what I refer to as an IRP. So I'll use IRP a lot. But again, anybody can access this. So to the extent you're looking to draft your own IRP or you're updating your IRP, just feel free to use the IRP checklist that we drafted. And the critical elements could be divided into a couple different groups where we have governance, roles, responsibilities, really the procedures themselves for discovering, response, and recovery, communication plans, and legal privileges and evidentiary protection. So the first part's usually the easiest, the governance, roles, and responsibilities. Here, your IRP is essentially identifying who the individuals are, whether internally or externally, that are going to have a role to play within your incident response framework. So you're going to have your incident response coordinator, the individual, the one person who really has the whole responsibility for coordinating and responding to a data breach or a cyber attack. Right? This is the person that's generally going to be delegated authority in some type of written notification, written memorandum, or just included in the IRP itself. You're going to have your internal resources, right? Obviously, your chief information security officer, your IT professionals who understand what type of data that your organization collects, where it's retained, who your third-party service providers. It's very important to have your HR officials involved, primarily because we've seen cyber attacks really over the last several years really focus in on HR data within an IT environment, because that type of information is going to be very sensitive. It could be social security numbers, passport data, well, benefits programs, 401ks. So it's really important that your HR team is listed and involved in your IRP, as well as your uh, outside counsel, IT consultants, your ransomware negotiators. And what I like to see is, for every incident response plan, is an annex that's attached that lists every single person who's involved in the incident response work, their phone number, the email, how they can be contacted 24 hours a day, 7 days a week, and backups in the event they're not available, given that so many of these data breaches happen over long weekends to make it more convenient for the attacker. We really have to have an incident response plan that lists all the important personnel and how they can be contacted 24/7, and making sure that list is up to date every month or at least every other quarter. So that's the easy part of the plan, right? That's just identifying the who, what, and when. Then you get into really the core of the procedures. So when dealing with incident response, it's generally a pretty well-founded framework that it's detection, analysis, recovery, and response. So detection is going to be really those technical security controls that your organization implements in order to identify anomalies or malicious activity within your environment. So this is going to focus in on your antivirus, your anti-malware software, any type of security system monitoring, any type of email scanning that takes place, and making sure you have the tools to identify, again, any type of malicious or anomalies that are taking place within your environment, and being able to ensure that individuals could analyze and assess that really within the immediate amount of time, or the most short amount of time possible. And that brings you into the next phase of assessment and escalation, right? You're analyzing the issues, the anomalies, and determining whether or not you really need to escalate this to implement your response plan and bring in IT consultants, your outside counsel, or whether it can be resolved internally. And if I could just stay on this note for a second, where my clients, I think, actually struggle is not in the ransomware context when it comes to assessment and escalation, right? Ransomware is easy. You can identify whether or not you see this type of malicious activity, whether you see your files being encrypted, whether you see malware being spread, and you know immediately that that needs to be escalated, and to bring in really a third-party IT consultant. The areas that my clients struggle with is when you have the unauthorized disclosure of data that's caused by an individual internally, right? When you have somebody in HR sending an email with social security numbers or benefits information to a wrongful recipient. So that's technically a cybersecurity event or incident that needs to be analyzed. And it's important because even though that's an incident that doesn't rise to the level of ransomware, it still could trigger data breach notification laws. And so the IRP, or incident response plan, should have a process for escalating those type of incidents as well that involve the unauthorized disclosure of personal information, but not to the same extent as potentially a ransomware attack. And then when focusing on the next issues, again, this is going to be more kind of IT involvement on containment, remediation, recovery, right? Ensuring that when you identify what the malicious activity is occurring within your network, being able to isolate it, segregate it from the rest of your environment, identify whether or not you've connected to third-party systems and where the risks are with that. And then importantly, recovery, right? Is your data able to be backed up? Do you have the ability to reconfigure your devices to allow a return to a normal state of operations? And if not, then you're faced with those really hard decisions on whether or not you have to pay a ransom in order to get access to your data or your information environment. And so the last two issues I'll hit upon is evidence preservation and your communications plan. Again, two key parts of an IRP that sometimes get looked over because they're not focused on those technical areas. So when responding to an incident, you really want to make sure that you have proper evidence preservation taking place, right? Whether or not your lawyers are issuing litigation holds, making sure you have a proper authentication process for ensuring you know who has access to your IT environment, whether it's internally or externally, keeping proper logs around that. In the event that any laptops or desktops are being removed from your premises for further analysis, making sure you have the proper chain of custody documentation. Right? This is all important part of evidence preservation and record keeping requirements that are going to be required under state and federal law. And then the last part I'll hit upon here is a communications plan. Part of this is understanding the type of data that you have. In the event you're subject to a ransomware attack, who would you have to notify, right? Your employees, your customers, your clients, your vendors, having a plan in place, having what I would refer to as template data breach notification letters attached to your incident response plan that could identify what these frameworks and communication plans look like. And a part of this is too also communications with law enforcement, whether it's state and local law enforcement, FBI, DHS, within DHS, Secret Service or CISA, right? You shouldn't be making decisions on whether or not, as a business, you're going to notify law enforcement at the time of an incident, right? These should be part of your communication plans and strategies ahead of a breach.
So if you do have a breach, obviously if you have an incident response plan, you're going to execute that incident response plan and start working through the, through the various steps you just outlined. There's a chance you may not have an incident response plan. What should you do in that case?
Usually the first thing that is in that incident response plan, if you don't have one, is contacting your counsel. And this is very important because when we respond to incidents like ransomware attacks, generally it's your outside counsel who is leading the investigation for the primary purpose to better protect the organization in the event of litigation, right? So when you have an outside counsel leading the investigation, they could assert the attorney-client privilege and the work product doctrine over the communications and the documentations that are produced during an incident. And this is going to be really important to the extent that you are bringing in an IT consultant or an expert to help do digital forensics or response and negotiate with the ransomware attackers themselves. This information oftentimes highlights potentially some of the vulnerabilities or weaknesses or measures that an organization potentially could have undertaken to better protect themselves ahead of an incident. And what we've seen in the last few years is organizations that are subject to ransomware attacks or data breaches themselves, whether from a third party or insider actor, inside threat, are subject to litigation. Even though they're the victim of the attack themselves, they're still subject to litigation, potentially for breach of contract, breach of fiduciary responsibility, claim, potentially negligence. And so as part of that litigation, you see plaintiffs, right, the end user consumers who have their information compromised, subject to attack, bringing these lawsuits, trying to get access to all the information that was developed during an incident response. And the trend has really been for courts to make it very difficult for organizations to assert the attorney-client privilege and work product doctrine in these type of situations. So again, it's very important that your attorneys are leading the investigation, that they're the ones hiring your IT consultants, that they're providing advice and counsel, they're receiving information in order to provide advice and counsel and prepare your organization for litigation.
Will the response for, if you have cybersecurity insurance in your professional liability insurance coverage, are the steps you're going to take different than if you didn't have insurance?
Generally not. It's obviously cyber insurance is very important piece of data protection. It's not the solution, but it's part of the answer to ransomware. Generally, when you have cyber insurance, your insurer is usually going to provide you with a approved list of outside counsel you can use, or approved list of IT consultants you can use, an approved list of ransomware negotiators you can use. Again, this should be built into your incident response plan, as these are individuals who are key stakeholders. I've noticed over the last few years that insurance companies have been much more willing to allow an organization to pick their own counsel to be pre-approved by a cyber insurance carrier. So they essentially, to the extent you're using your own preferred counsel, your own IT consultant, the expenses used in these scenarios would be reimbursable and recoverable under your insurance plan. But again, it's something you have to work with the insurance company before a breach. You don't want to be raising these issues as you're also responding to an incident yourself. And I'll say it's really important to test your incident response plan. Test it with the individuals who are approved by your insurance company to as your panel counsel, your panel IT consultant. So when you're doing tabletop exercises, bring in your approved outside counsel, have your IT consultant be running these TTXs for you. Because again, the first time you meet your approved legal counsel for a data breach shouldn't be during a data breach. It should be as part of your preparation for these incidents.
And you mentioned tabletop exercises. How effective are tabletop exercises in replicating an actual data breach? And are you, is that really a robust test of your incident response plan?
I think it is it's a good part of your incident response plan. It's one part of that. You should also be doing other type of security controls and checks. Obviously, if you can, bring in a third-party vendor to do what we call penetration testing, vulnerability scans of your environment. The tabletop exercise, I think, is very important for a few reasons. First, it confronts individuals within an organization with the decisions that they're going to have to make in the event that there is a real world ransomware attack or a data breach, right? You're confronted in a scenario on whether or not you're going to notify law enforcement. You're confronted with a scenario on whether or not you're going to notify your customers, your employees, and if so, how. Again, notification, whether or not you're going to pay a ransom, whether you're going to negotiate it, if so, to what extent, what risk you're willing to take. So in those areas, I think it brings type of scenarios to the fore that otherwise people aren't thinking about. And then again, second, it brings together groups of individuals that generally don't meet on a routine basis. I think data privacy is a group of strange bedfellows in that it brings HR, IT, ethics, legal together. And so the extent you're doing a tabletop exercise, it gets people to know each other a little bit better. Again, it gets the opportunity to meet and work with your outside consultants, your IT consultants, or your outside counsel and your IT consultants as well.
Okay, and one word answer. So we can move on. If you're doing a tabletop exercise for the people internally within your organization, should it be a surprise or pre-planned?
So when you're doing all the TTXs that we usually do are pre-planned, just because you're trying to reconcile schedules.
Okay.
But other tests you should be doing, phishing tests, vulnerability scans, penetration tests, those are usually ad hoc.
Okay. The question from the audience is the SEC's definition of reportable cyber incident consistent with FinCEN's? And should a fund or advisor consider filing a voluntary SAR-SF with FinCEN?
So these are one of the issues that the government is wrestling with right now, especially at the federal level, regarding duplicative reporting obligations and whether or not an organization is subject to multiple different federal regulations, whether they have to do reporting across the board. So first and foremost, the definition itself is actually very consistent with the types of definitions of data breaches that we're seeing in a lot of other contexts, including, like I said before, the consumer protection context, but also what we see for defense contractors and government regulators, what we see in the HIPAA context for dealing with healthcare information. The definition is surely very consistent across the board, because usually these definitions of cybersecurity incidents, right, they're going to, again, involve whether or not you're dealing with IT operations, critical operations, or the types of data being compromised. And so one of the issues, again, that we are struggling with within the private sector is the fact that so many of our clients are subject to these different regimes that require data breach notifications, notifications of cybersecurity incidents. At the state level, they're much better at essentially acquiescing, primarily because of federal preemption, that essentially if you have to make a report to one federal agency, that would also satisfy most of your obligations at the state level. We don't have that same consistency yet at the federal level. Essentially, if you're subject to different regulators, usually because you're dealing in different data sets or you're in different sectors, you have to routinely do those reporting obligations across the board. And essentially one disclosure to a regulator does not necessarily preempt your obligation to disclose to a second regulator.
Okay. Thanks. That's great. And so just really briefly also, there are like 50 state, like you have state reporting obligations. And so you need to look, I suppose, at where you're doing business or where your customers are to determine whether you're subject to any state reporting obligation.
Yeah, absolutely. That all 50 states have their own data breach notification laws. There's a goal of hopefully the federal government would preempt all of those states and just require one have one notification law. We're generally not seeing that as much as we saw a few years ago. So it's not just right where your customers are, where your employees are, where your vendors are, because it's all going to depend on the type of personal information you're collecting to determine whether or not you're going to be subject to these state laws. And again, they're very consistent across on what the reporting obligations are, but vary in important aspects like timelines on how quick you have to report an incident, what the content needs to include, things like that.
Okay, thank you. So you may have noticed that Steve didn't mention any reporting obligations for registered investment advisors or registered funds to report cyber incidents to the SEC or any other any other regulator. That's because currently there are no obligations specifically requiring registered investment advisors or registered funds to report. However, actually last month, the SEC proposed rules related to cyber risk management for registered investment advisors, registered investment companies, and business development companies. Excuse me. And the rule would require funds and advisors to adopt and implement written cybersecurity policies that are designed to address those cybersecurity risks that could harm advisory clients and fund investors. And the rules for the advisors, the proposed rules for the advisors and for registered funds are virtually identical, and they really require 5 elements, some of which luckily Steve has already addressed, and hopefully advisors and funds already have some of these in place. But if the rule is adopted, obviously we'll have to go back and look at overall at their cyber security architecture to make sure that they're covered and to supplement where necessary. We'll just go through some of the 5, actually all of the 5 elements. One is a risk assessment. So advisors and funds would be required to periodically assess their cybersecurity risk. And this would include categorizing and prioritizing the risk to the fund, and advisor information systems, as well as the information held on those systems by the fund and the advisor, and also identifying service providers that receive, maintain, or process fund or advisor information, or have access to fund or advisor information, and assess whether the cybersecurity risks associated with assess the risks associated with their access to the information. So, Steve, can you talk a little bit about this new requirement and how it is applied in other contexts, or how you've seen it applied in other contexts?
Yes, sir. And this is kind of the information security part of this, both protecting your IT environment as well as the data that's retained and transmitted on that. It's a common theme we've seen across the federal government. Just last week, as part of the Ukraine and Russian conflict, the Department of Homeland Security and FBI issued an alert to businesses about potential risks to their own IT environment from ransomware attacks that would be caused by a Russian or a Moscow-sponsored agent. And so they essentially focused on provided businesses, requiring them to focus on, multi-factor authentication, doing antivirus, anti-malware scanning on a regular basis, strong email filtering, making sure you're updating your software and patching your systems. It's really the same type of recommendations that the White House made last year when they drafted an open letter to business suggesting that they implement certain technical security controls to better protect themselves from ransomware, which again included multi-factor authentication, encryption, ensuring your data is backup so you don't have to pay the ransom in the event you could recreate your data environment, doing penetration scan, vulnerability scans, and testing your incident response plan. Right, these security controls that we see the government issuing both in formal statements and advisories, and now potentially in regulations, right, they're the same controls that the government has been recommending for years. Now we just see in this SEC proposed rule kind of mandating it on certain advisors, investors, and organizations.
And so, and Steve sort of highlighted this already, that the next 2 requirements relate to user security and access and information protection. And so the proposed rule would require controls to minimize user-related risks. These involve, for instance, the adoption of an acceptable use policy, identifying and authenticating users. Steve just mentioned 2-factor authentication, adoption of policies for the periodic replacement and revocation of passwords and authentication, limiting access of information to those people who need to know the information, and securing remote access to various technologies. On the information protection front, the proposed rule will require measures to monitor information systems and protect advisor and fund information from unauthorized use or access, and require oversight of service providers that, again, receive, maintain, or process fund and advisor information, or have access to fund and advisor information, and importantly, contractually require those service providers to implement and maintain appropriate measures to protect fund and advisor information systems and the information on those systems. So these two requirements focus on more technical controls. Steve, could you talk about your experience here?
Sure. I think you hit upon one that is very common in the data protection context, which is oversight of service providers. The way that your information security works is you're only as strong as your weakest link. And if you're using third-party service providers to retain information on your behalf or regulate or operate your IT environment, you're only as strong as those service providers are. And so what we see really in other contexts that we didn't see so much in the SEC proposal is laws requiring organizations to enter into contracts with their service providers that include certain provisions, right? Requiring service providers to implement their own technical, physical, administrative security controls and identifying those controls in the contract for the business to approve as being sufficient. Requiring confidentiality among their own employees of the service provider, requiring them that they dispose of data at the end of the contract in a certain way, potentially that they retain data within the United States so you're not exposed to foreign data protection laws. So the SEC proposal is somewhat broad in this area compared to what other requirements are, but this is also an area that is a best practice that organizations should really be considering vendor management as part of their data protection processes.
Thank you. And the last two cyber requirements relate to risk management and incident response. Specifically, the proposed rule will require funds and advisors to implement procedures to mitigate and remediate any cybersecurity risks and vulnerabilities with respect to fund and advisor information and their, fund and advisor information systems and information on those systems. And then the last requirement is something that Steve talked about in great detail at the beginning, adoption of a cyber incident response and recovery plan. So these would be designed to detect, respond to, and recover from a cyber incident, including the ability to continue your operations, to protect fund information, to communicate and share information internally and externally about the cyber incident. And most importantly, the new thing here is that report this significant cybersecurity incident to the SEC. And this reporting would be done by the advisor, either the fund advisor or an advisor managing separately, separately managed accounts or a private fund. That reporting would be done on a new form that the SEC has developed called Form ADV-C. And as Steve mentioned earlier, they would be required to be filed promptly after the discovery of a significant cyber advisor incident or cyber fund incident, but no later than 48 hours later. And if this, and it would also need to be amended. An amended Form ADV-C would have to be filed if any information in the original filing is found to be inaccurate, or new information is developed or discovered, or the cyber incident is resolved, or the internal investigation pertaining to that incident is closed. So there'd be an initial filing requirement as well as a subsequent amendment if necessary, all done within no more than 48 hours after the incident. Do you think this is 48 hours is a reasonable time period?
So whether or not it's reasonable versus whether or not it's a legal requirement are going to be two different standards. And we do see legal requirements that require, in other data protection laws, require notification within a 72-hour period. And the way that those have been really implemented over the last several years is kind of memorialized in the SEC rule, in that usually the government entity is just looking for an initial notification to put them on alert, and then the follow-up notifications. I think the follow-up notifications within the 48-hour window itself is a little bit unique here. But it's because within the first 48 hours, right, you're still putting out the fire. You're still doing a lot of investigation, and so I can see the initial report obviously being very, very broad and high level, drafted in a way that it doesn't look like you're revisiting some of the conclusions you may originally be defining in a report. So the 48 hours I think is very tough, but I think we've had experience in other data protection laws on how this is being applied, and really doing a reporting that's accurate to the greatest extent possible, but also cautious in recognizing that things change and new information comes to light as the investigation unfolds.
Yeah, I think if you look at the proposed form ADV-C, it's pretty much a check the box type form responding to questions. I think there's one narrative question asking for a description of the incident, but that's the only thing. And then I guess also since you can amend it, they have the amendment obligation. You can be broad, as you say, in your initial filing, and then provide a little bit more details as you learn more, as you continue to investigate. In addition to the filing requirement, it's also a requirement that funds and advisors annually review their cybersecurity policies and procedures and provide a written report, which would then be stored in the fund and advisors' books and records. There's also a disclosure requirement. This is new, and I suspect will generate some pushback from the industry. But there's a requirement that advisors in their Form ADV and funds in their prospectus disclose any cyber incidents that occurred in the last 2 fiscal years. Steve, do you have any? I think we've come to our end of our time, and we've actually gone a little bit over our time, so we appreciate everyone who's hung in with us. Steve, do you have any final comments you'd like to make?
I just think what you're seeing in the SEC proposal is really part of a larger trend within the U.S. federal government of having very sector-specific rules in place, but the rules around information security, data protection, data breach response are generally consistent across the board. It's just how they're being implemented and applied in the individual sectors that are causing this variation, and unfortunately creating a patchwork in which organizations have to comply with different standards across the board. But generally it shouldn't be, none of this is really going to be seen as new for organizations, as they are likely subject to these and potentially other areas of law as well.
Okay, well, that concludes today's chat. If you have any other comments, please put them in the Q&A box now. Our next coffee chat will be held on Wednesday, March 16th. My colleague Joanne Strasser will be discussing the impact of the new valuation rule on fund advisors. She will be joined by Julie Roach, who's the treasurer for the Diamond Hill Funds, and I think she was a former treasurer for the JP Morgan Funds and an auditor at Deloitte. So she's very qualified to talk on that subject. Thank you for joining us weekly over the last year. If you've missed any of our past coffee chats, we encourage you to view our library of recordings, which are available on Thompson Hine's YouTube channel. Thank you for attending today's program. I want to extend a special thanks to Steve for sharing his insights. When this webinar ends, you'll be prompted to take a brief survey to provide feedback for us. This feedback is very important to help us continue to tailor our programs to your needs. Thanks again. Enjoy the rest of your day and stay well.